What is the sneakiest clause you've ever found in a contract? Story 1. When my company decided to switch to a new payroll provider, we were sent a detailed contract to review. It seemed routine at first, but as we carefully went through the terms, something disturbing caught our attention. Buried within 3 pages of fine print were multiple clauses stating that the provider would not be held responsible for the security of our employees' sensitive information, including their social security numbers and banking details. This immediately raised red flags. After all, ensuring the safety of such critical data was one of the main reasons we were outsourcing payroll management in the first place. Concerned, we reached out to the payroll provider for clarification. Initially, they acted like they didn't understand what we were asking. They brushed off our concerns and pretended it was no big deal. When we pressed them further, their demeanor changed. The casual tone disappeared, and they became defensive, almost aggressive, trying to dismiss our concerns as trivial. We weren't satisfied with the lack of transparency and continued asking why they wouldn't take responsibility for safeguarding our employees' private information. Eventually, after enough back and forth, they came clean. The truth was, they didn't want to be held liable in the event they were hacked, or if a disgruntled employee accessed or took off with confidential payroll data. They openly admitted they were covering themselves legally to avoid lawsuits if any breaches occurred. Hearing this was alarming, to say the least. If they weren't willing to take responsibility for data security, what else would they avoid accountability for? It was clear that this company didn't have our best interests in mind or a solid plan to protect our team's sensitive information. After much discussion within our own company, we unanimously decided to walk away from the deal. We couldn't risk our employees' trust and privacy being mishandled. Needless to say, we did not sign with them and continued looking for a payroll provider that understood the importance of security and accountability. In today's world, where data breaches are all too common, protecting our team's personal information was non-negotiable. Story 2. Here's a story that's not quite the same, but definitely relevant. I used to be responsible for writing the minutes for a monthly meeting at my workplace. Like clockwork, I would meticulously type out everything that was discussed, every action item, and every decision made. But here's the thing. No one ever actually read the minutes. It was almost comical how, at the start of each meeting, we would go through the formality of voting to approve the minutes as a true and accurate record of the previous meeting without anyone paying the slightest bit of attention to what was actually written. They'd all nod, agree, and move on. After a few months of this, it became clear that the minutes were just a formality for the group. So, as an experiment, and maybe out of a bit of cheeky frustration, I decided to test how closely anyone was paying attention. After one particular meeting, I added a little extra something into the minutes. The chair agreed to buy everyone drinks all night at the local pub after the next meeting. I slipped it in there quietly, fully expecting someone to notice it and call me out on it. But as usual, the next meeting rolled around, and the minutes were approved without a single word or raised eyebrow. That night, we all found ourselves at the pub, enjoying drinks on the chair's tab. To my surprise, they went along with it in good spirits, even though it was clear they hadn't agreed to it during the actual meeting. We all had a great time, and everyone enjoyed the unexpected round of drinks. But the real twist came afterward. Word got around, and from that point on, everyone started paying much closer attention to the minutes. No more rubber stamping without a second glance. People actually began reading through the minutes carefully to make sure nothing like that would slip through again. It was a small, harmless prank, but it definitely got the message across. If you're going to approve something, you'd better know what you're agreeing to. Story 3. This story might be a bit of a stretch in relation to your question, but it's definitely in line with some of the other responses. So here goes. My sister-in-law, who sadly has passed away, once took a job with a major hardware store chain, not Home Depot for clarification. It was her first real job, and shortly after being hired, they had her sign what seemed like a routine credit card application for an American Express card. At the time, she didn't think much of it. She was young, not particularly financially savvy, and figured it was just part of the paperwork that comes with a new job. She signed it and forgot about it as the months and years passed. Fast forward 3 years, and the company decided to lay her off. She was upset as she'd really liked her job, but there wasn't much she could do about it. Then, a few months after her termination, something unexpected arrived in the mail. A notice from the company demanding that she relinquish her rights to the American Express membership rewards points accumulated on the card. They wanted over 1.5 million points back. Turns out the company had been using her credit card without her knowledge or formal authorization to pay for travel expenses related to the sales team. Things like airfare, hotels, car rentals, and more. For 3 whole years, they'd been charging thousands of dollars in expenses to her Amex account, and in the process, her card had been racking up millions of rewards points. The catch? The points belonged to her, Naturally, my sister-in-law and my brother were furious when they discovered what had happened. They hired a lawyer, and after some back and forth, they managed to negotiate a settlement with the company. It turns out that while she had signed the card application, she had never formally authorized them to use her credit for company expenses. The company, fully aware they were in the wrong, knew they faced potential legal consequences if they took it to court, both for unauthorized use of her credit and potential liability for other unlawful practices. As a result, she got to keep every single one of those points, and let me tell you, they lived well off them for years. They took not one, but two virtually all-expenses-paid trips to Hawaii. On top of that, whenever they wanted a quick getaway, they'd fly out to visit family members, including me, without a second thought, using those same points. It became a running joke in our family about how they were living high on the hog, all thanks to those rewards. Story 4. When I started working for a small tech firm, I had to sign a non-compete and non-disclosure agreement. Pretty standard stuff in the industry. Everything seemed straightforward, and I didn't think much of it at the time. Part of my job required some travel, and the company covered all the expenses as expected. Things were fine until I decided to leave the company. That's when things took an ugly turn. A few days after I quit, the owner contacted me, claiming that I owed him money for all the travel expenses the company had paid for during the 2 years prior to my departure. He insisted it was part of my contract, and that I had agreed to reimburse the company if I left within 2 years. This caught me completely off guard because I had never seen any such clause in the contract I signed. Something felt off. Fortunately, I had been meticulous when I filled out my employment paperwork. I had initialed each page of the contract, and as a precaution, I asked the secretary to make me a copy of the entire document on my first day. I didn't realize how important that would be later on. When I pulled out my copy, I quickly realized what had happened. The owner had added 4 extra pages to the contract after I had signed it and forged my signature on them. He had essentially rewritten part of the agreement without my knowledge, making it seem like I owed him for those expenses. As if that wasn't bad enough, it turned out I wasn't the only one he had pulled this trick on. 2 other employees who left around the same time were also hit with similar claims. One of them, like me, had kept a copy of their original contract. Together, we realized the owner had been doing this to everyone who left the company, altering contracts and forging signatures to extort money from his former employees. The owner's lawyer filed a lawsuit against the 3 of us, demanding repayment of those supposed expenses. But with proof of the forgery in hand, we were able to counter the case and have him investigated for fraud. As it turns out, the situation became even more tangled when personal drama got involved. The owner's fiancée was the daughter of his lawyer, the very same one representing him in the case. What he didn't know, but I did, was that he had been secretly having an affair with one of the women who worked in the accounts payable department. One phone call to his fiancée later, and she showed up to confront him. She caught him red-handed, in his van, no less, with the woman from accounts payable. After that, everything spiraled out of control. His fiancée called off the engagement, and her father, who had been the owner's lawyer, immediately cut all legal ties with him. With no legal representation and mounting evidence of forgery, the case completely fell apart. Story 5. This story isn't so much about a sneaky clause in a contract, but more about the clever exploitation of a policy loophole. I spent many years working for various federal government departments, and as you might expect, these organizations often hired expensive consultants for various projects or initiatives. It was a pretty common practice, and the mentality was essentially, it's just taxpayer money, right? In fact, bringing in high-priced consultants served a dual purpose. If something went wrong down the road, the higher-ups could just point to the consultant and say, "Hey, we did our due diligence and hired an expert." It was a bit of a shield for them when things inevitably fell apart. To try and curb the ridiculous amounts of money being spent on consultants, a rule had been put in place some years ago. The rule said that if a consultant was hired for only a short-term period, they could be paid at high hourly rates, which were often exorbitant, sometimes upwards of $400 an hour. However, if that consultant remained on the job for more than a certain amount of time, I believe it was around 6 weeks, they were supposed to be switched over to a more economical, long-term contract. This would lower their hourly rate, but provide them with a steadier income. It was a system designed to prevent the government from bleeding money over an extended period. Well, one particular consultant managed to take advantage of this situation brilliantly. He was brought in to work for a few high-ranking bosses within the department, and to justify his high hourly rate, he was assigned to multiple departments, essentially bouncing from one to the other. This way, he was always working on something important and, theoretically, never idle on the government's dime. It was all above board. So far, so good. But here's where things got interesting. When the 6-week mark rolled around, the time when his contract should have been switched to the lower long-term rate, something odd happened. Nothing. The consultant was working for so many different bosses that each one assumed someone else had handled the contract change. None of them wanted to take on the extra work, and they certainly didn't want to admit that they had enough free time to deal with it, because doing so might lead to their own bosses piling more work onto them. Plus, the expenses weren't coming directly from their budgets, so there was no real incentive for anyone to chase it up. As a result, no one signed off on the change, and the consultant continued to clock in at his hefty hourly rate, $400 an hour, for over a year. He came in early, left late, and diligently submitted his timesheets, all while raking in an incredible amount of money. By the time an audit finally flagged the issue, the department had paid him over $1 million. Story 6. I once worked with a lawyer who insisted on drafting his own NDA, non-disclosure agreement, for a consulting project I was involved in. Normally, NDAs are straightforward documents, often 1 or 2 pages long, covering the basic confidentiality, non-compete clauses, and protection of sensitive information. However, this particular NDA was far from ordinary. It stretched nearly 10 pages long. My experience told me that when a document is that lengthy, it's likely stuffed with excessive terms, and this one was no exception. Curious, I read through it meticulously page by page. To my astonishment, it was filled with clauses that seemed not just extreme, but borderline absurd. One clause stated that I agreed not to work with anyone I so much as spoke to during my time consulting for him, regardless of whether the conversation pertained to his business or not. Essentially, if I bumped into someone at a cafe during this project and we talked about the weather, I'd be barred from working with them in the future. Ridiculous. Another clause stood out even more. He claimed complete ownership and licensing rights to anything I created or conceived of during the time I worked for him. Not just work-related content, but anything I came up with, even if I didn't jot it down or if it had no connection to his business. Whether I thought of a novel business idea while taking a shower or sketched a design in a notebook on my own time, he was claiming rights over it. The audacity of it all was staggering. There was no way I could agree to these terms, so I pulled out my red pen and went to work. I redlined the document heavily, crossing out the most outrageous sections, and attached a much simpler NDA that I typically used in my consulting, one that was fair to both parties and followed standard legal practices. I wasn't sure how he would react to my edits, but I wasn't about to sign something that could jeopardize my future work or intellectual property. To my surprise, he didn't push back. Perhaps he realized that the original version was overkill, or maybe he just wanted to get the project moving. In the end, we both signed the standard NDA that I had provided. It was a relief to have that behind us, and it was a reminder of how important it is to scrutinize every detail of legal documents, especially when they come from lawyers who think they can get away with more than they should. Story 7. As a lawyer, I've developed a little habit that has served me quite well over the years. Whenever I'm asked to sign a form at any retail business, I make it a point to hand it back to them unsigned. If the person handing me the form notices and asks for my signature, I don't make a fuss and sign it. But more often than not, they don't notice, and I move on without a signature. It might sound like a small thing, but it saved me from potential headaches more times than I can count. One incident in particular stands out. A friend of mine had left a golf club at my house, and I wanted to return it to him. So I carefully boxed it up and headed to the local UPS store to ship it. Everything seemed to be going smoothly. The clerk handed me the typical form, one of those that contains the infamous, "We aren't responsible for your cow" clause. Basically, a disclaimer saying they won't be held accountable for damage or loss of your items. True to my habit, I took the form but didn't sign it. The clerk didn't seem to notice, and off my friend's golf club went. Fast forward a few days, and my friend calls to let me know the package has arrived, except the golf club is now in 2 pieces. I couldn't believe it. How do you even break a golf club in transit? Did they fold it in half or something? I was furious. So I picked up the phone and called UPS to file a complaint. As expected, their first line of defense was, "But you signed a contract, and we aren't liable for the damage." That's when I smiled and said, "Good luck finding my signature on that contract." They were silent for a moment before realizing they had no signed agreement to back up their claims. Without my signature, their argument fell apart, and I managed to negotiate $400 in compensation. It was no easy task to replace a single iron from a set of golf clubs, so the payout was a small victory. I had no ethical qualms about it either. Companies like UPS rely on the fact that consumers often don't read or fully understand the fine print in contracts. They use that to their advantage. So I figure it's only fair when I turn the tables by relying on their employees' failure to notice a missing signature. In the end, it's a game of paying attention, and this time I came out on top. Story 8. About 13 years ago, my father was diagnosed with cancer, and as his health deteriorated, he could no longer manage his business or handle his financial affairs. Unfortunately, his firm began to struggle, and it wasn't long before the bank came after him. Given his illness, my sister and I had no choice but to step up and try to manage the situation on his behalf. It was a terrifying and overwhelming time, but we were determined to help him. We were lucky enough to find an excellent lawyer, someone who understood the nuances of the situation and was willing to fight on our behalf. The bank, however, was ruthless. They claimed my father owed them a significant sum based on a credit contract he had signed back in the 1990s, when Portugal was still using the escudo as its currency. When our lawyer requested to see the original contract, we found something truly appalling. Someone from the bank had actually altered the document by scribbling the euro symbol, euro, over the original escudo currency symbol, which looked similar to the dollar sign but with 2 vertical slashes. This blatant and illegal alteration was a game-changer for us. Our lawyer immediately recognized the significance of this tampering. The alteration was key to our defense, and it helped us fight back against the bank's aggressive tactics. It was a clear indication that the bank wasn't acting in good faith, and their dishonesty became a crucial part of our case. This discovery gave us leverage we desperately needed, and it's one of the primary reasons we were able to stand up to them and win. What truly disgusted me about the entire ordeal was the bank's sheer greed. My family and I were not trying to evade our responsibilities. We were more than willing to settle my father's debt. We even offered them some of our properties, well-located properties that were worth more than the amount my father owed. But the bank wouldn't hear of it. They claimed the properties weren't worth enough and demanded that we surrender everything, including the home where we lived. Their goal was to strip us of all our possessions, leaving us with nothing. It was cruel beyond belief. Even after all these years, the memory of that period fills me with anger and bitterness. My family was going through one of the most difficult times in our lives, watching our father battle a terrible illness, and the bank showed no compassion or understanding. To this day, I still hope that those responsible for trying to ruin our lives experience the same suffering they caused us. We were lucky to fight back and win, but the scars from that experience remain. Story 9. I'm a little late to the conversation, but I remember a fascinating story that made headlines in the local paper about some of the lowest rent in the city. It was incredible. 2 people were living in a 50-square-meter apartment in one of the more desirable parts of town, paying only $84 per month. To put that in perspective, in today's market, a normal rent for a place like that would easily be 10 times that amount, if not more. In fact, $84 a month wouldn't even be enough to rent a parking space in the city. The backstory behind this deal was both amusing and insightful. It all started in 1977 when the owner of the apartment complex decided he wanted to sell the building. However, the housing laws at the time were structured in a way that he couldn't simply put the apartments on the market. Before selling, he had to offer the current tenants the opportunity to purchase their units through a housing equity partnership. The owner, not wanting the hassle of tenant buyers, devised a plan to discourage them from taking up that option. He drew up a contract that froze the rent at its current rate indefinitely. The tenants who signed the contract wouldn't have to worry about rent increases ever again. Most tenants probably didn't realize the long-term benefit of such a contract, but 2 brothers certainly did. They still live in one of the apartments to this day, paying the same $84 a month they've paid for decades. Over the years, the owner of the building, realizing what a financial loss he was facing with such low rent, tried everything he could to get the brothers to move out. At one point, he even offered them the equivalent of $100,000 each to leave the apartment and free up the space. But the brothers, having seen how far their rent went in comparison to the skyrocketing market prices, refused to budge. Frustrated, the owner decided to take them to court, hoping to break the contract and reclaim his property under more favorable terms. Unfortunately for him, the court upheld the original agreement, ruling that the contract was valid and binding. As a result, the brothers are still living in that apartment at the same dirt-cheap rent, and the owner is stuck with his self-inflicted problem. It's one of those rare cases where the underdogs, armed with a bit of legal luck and foresight, come out on top, and the landlord's attempt to outsmart the tenants backfired in a spectacular way. Even now, that $84 a month for an apartment in that part of the city feels like something out of a fairy tale, a relic of a different time in the housing market. Story 10. This might not be exactly what you're looking for, but it's a story about some guys who thought they could sneak their way around the law, only to have their plans backfire. My dad started an online pharmacy business in Canada that primarily sold sweets to customers in the US. It was more of a side venture for him, something he did in addition to his real job. However, it started to bring in decent money once he teamed up with a couple of local pharmacies that handled the order fulfillment. Everything seemed to be running smoothly until the owners of those pharmacies approached him with a proposition. They offered to take over more of the workload, handling the increased order volume in exchange for a higher percentage of the profits. My dad, being busy with his main job, thought it was a good idea. There was no formal contract, just a verbal agreement. He figured it would free up his time, and he trusted the pharmacy owners to honor the arrangement. Initially, they seemed to stick to their word, running the site while sending my dad his share of the profits. He suspected they were skimming a little off the top, but since the checks were still decent, he didn't make a fuss. However, over time, the payments became slower and less frequent. Eventually, they stopped altogether. When my dad confronted the pharmacy owners, they told him they were planning to sell the business. According to them, the website had grown so much that a larger company had expressed interest in buying it. They offered my dad $40,000 as his share of the sale. Now, there were a couple of huge issues with this. First, they still owed my dad back payments, which should have been much larger since the site had apparently grown. Second, and more importantly, they didn't actually own the website. They had no right to sell it in the first place. My dad was still the sole owner, and these guys were trying to pull a fast one on him. Sensing something was off, my dad did some digging. He managed to find out who the potential buyer was and contacted them directly. That's when he discovered the pharmacy owners were negotiating a sale price of $400,000, not the $40,000 they had told him. They were trying to pocket 90% of the sale and give him a measly 10%, despite the fact that he owned the entire business. My dad wasn't going to let them get away with it. He informed the prospective buyers that he would be selling the website himself for the full $400,000. In a generous move, he told the pharmacy owners he would give them each $20,000 for their troubles, even though they didn't deserve it. Instead of accepting his offer, they got angry and threatened to sue him, thinking they could intimidate him into giving them more. But my dad, being calm and confident, welcomed the lawsuit. He knew they didn't have a leg to stand on. After a single meeting between my dad, the pharmacy owners, and the lawyers, it became crystal clear to them that their threats were empty. The lawsuit never materialized. My dad went on to sell the site for the original offer of $400,000, and the pharmacy owners walked away with nothing but regret for trying to outsmart him. Story 11. I work as an attorney for a major university, handling various legal matters, including contracts and agreements. A few years ago, the university put out a bid for a nearly all-encompassing dining services contract. This contract would cover the entire campus, with the exception of one key area, the libraries. After a competitive process, Company A, a well-established dining services provider, won the bid and was awarded the campus-wide contract. This meant that Company A would provide food services to the majority of the university, including dining halls, cafes, and other eateries scattered across campus. However, since the libraries were not included in that initial contract, the university later issued a separate bid specifically for dining services within those buildings. Interestingly, Company B, which happened to be Company A's primary competitor, entered the race for the library contract. After a careful evaluation, the university awarded Company B the contract to manage dining services in the library spaces. As is typical with contracts, Company B's agreement included several detailed exhibits. One exhibit in particular focused on the technical specifications. This exhibit contained essential information, such as the number of ovens, the staffing levels, and other operational details. However, as my team and I combed through the contract, we stumbled upon something highly unusual and suspicious. Buried deep within the technical exhibit, on the very last page and written in a tiny 6-point font, was a hidden clause that read, "University hereby terminates its contract with Company A and hereby appoints Company B as the exclusive provider for all dining services." This was a sneaky attempt to overturn the original campus-wide contract with Company A and hand over exclusive rights to Company B. Had it gone unnoticed, the entire university's dining services would have shifted to Company B, causing significant disruption and potential legal consequences. Fortunately, we caught the deceptive clause before the contract was finalized. We immediately flagged it, brought it to the attention of the appropriate university officials, and removed the clause from the contract. It was a stark reminder of how critical it is to thoroughly review every word in a contract, no matter how small or seemingly inconsequential the font may be. Story 12. I once worked on a massive white-collar criminal case involving healthcare fraud. It was one of the most complex cases I'd encountered, with numerous defendants, including the chief legal counsel of a major health maintenance organization, HMO. What made this particular case stand out was how this chief counsel, who had been a key player in the company for years, had brilliantly protected himself long before the fraud case emerged. Years earlier, in a display of foresight, or self-preservation, this individual had negotiated an exceptionally favorable indemnification clause with the company. This clause required the HMO to cover all legal defense costs for him, even when it came to criminal charges, like the ones in this case. It wasn't just a basic agreement to pay his legal fees. The clause had been meticulously crafted to shield him almost entirely. If the company ever tried to contest or dispute its obligation to cover his legal defense costs, the clause required the HMO to also pay for his legal expenses to fight that dispute. Essentially, the company was trapped in an ironclad agreement. No matter what legal strategies they tried, they were obligated to foot the bill for this individual's defense, even if it was against their own interests. As a result, the defendant ended up racking up tens of millions of dollars in legal fees, all covered by the company that he had once represented as chief counsel. The contract, although involving a Florida-based HMO, was to be interpreted under Delaware law. This detail is important because under Delaware corporate law, indemnification clauses like this one are fairly common, but I had never seen one so entirely tilted in favor of an individual. It was a one-sided arrangement that essentially made it impossible for the company to cut its losses or fight back without risking further financial liability. In the end, this strategic legal maneuver added an entirely different dimension to the case. While the fraud charges themselves were serious, the company's internal struggle to free itself from paying astronomical defense costs became a saga of its own. It taught me a valuable lesson about the power of well-negotiated contracts and how they can serve as a defendant's shield, even in the face of serious criminal allegations. Though this case received a great deal of attention, it's important to clarify that it wasn't the infamous Rick Scott case. Nevertheless, the contract's design was a masterpiece of legal engineering, and it still stands out in my memory for how thoroughly it protected one individual at such an astronomical cost to the company. Story 13. Then others. I didn't pay much attention to that until I got into a bad car accident. My car was totaled, and I was pretty banged up. I quickly realized I didn't have medical insurance, and as soon as the hospital found out, they yanked away my crutches and braces and practically shoved me out the door with a fat bill to pay. Feeling completely stuck, I started digging through that pile of insurance paperwork and came across a clause that blew my mind. It said that if I was in an accident where the airbags deployed and I was wearing my seatbelt, I was eligible for special medical coverage, up to a pretty large sum of money. So I called the insurance company and spoke to a bunch of people. They all told me that the clause wasn't valid anymore. But the next day, I got a call from someone much higher up in the company, probably a lawyer or some big shot. Turns out, a few hundred of those insurance packets had accidentally gone out with that outdated clause, which had actually expired 5 years earlier. They ended up agreeing to send me a check. But here's the kicker. They also said they were cutting ties with me. On top of that, they wanted me to sign something to absolve them of any further responsibility. Long story short, always read the fine print. Don't be afraid to ask questions either. You never know what might be hidden in those pages, and it could save you a lot of hassle. Story 14. Back in grad school, I was desperate to find a cheap apartment, and the options were slim. This was before Craigslist existed, so I found a post on a literal bulletin board at school about a room for rent. I met up with the girl renting the room, and everything seemed fine. She seemed okay with me, so I went ahead and signed the lease without overthinking it. I was just relieved to have a place to stay. However, things changed as soon as I moved in. Suddenly, she started laying down all these extra rules that she hadn't mentioned before. For example, she wanted me to put my TV in the basement and only use the bathroom downstairs, even though the bathroom upstairs was right next to my bedroom. It quickly became clear she was trying to control more than just the space. She wanted to dictate how I lived. One day, I was sick and didn't feel like trekking down to the basement bathroom, so I used the upstairs one, which was more convenient. That's when she snapped. She started yelling at me for using her bathroom. It became clear that this living situation wasn't going to work out, and I felt increasingly uncomfortable in what was supposed to be my own home. As I started looking for a way out, I decided to actually read the lease I had signed. That's when I noticed something strange. There was a clause that said, "This contract is null and void if rent is not paid by the 7th of the month." This gave me an idea. I realized that if I didn't pay the rent on time, the lease would be invalid, and I could leave without facing any legal consequences. So I decided to move out. I packed my stuff, left a note explaining why I was leaving, and just walked away from the whole situation. Not long after, she called me, absolutely livid, screaming at me over the phone. "That clause was for my protection, not yours," she yelled. But hey, it was in the lease, and I used it to my advantage. The situation taught me a valuable lesson about reading contracts carefully, even the small print, because sometimes there might be something in there that works in your favor, even if it wasn't intended that way. Story 15. Ironically, one of the strangest legal situations I found myself in was with my own lease agreement. At the time, I was in law school, and my significant other and I were living in an apartment that was decent overall, but it had terrible plumbing. The plumbing system was shared between apartments, and we lived in the top unit, So whenever something went wrong below us, we often got dragged into the problem. One day, the plumbing burst in the apartment beneath ours. The apartment complex management immediately pointed the finger at us, claiming that we had been putting pasta down the drains and that it had caused the pipes to clog and burst. It sounded ridiculous, but to make matters worse, they pulled out a clause in our lease that allowed them to fine tenants for damaging the plumbing, specifically by putting pasta down the drains. Not grease, not large objects, not anything you might expect, but specifically pasta. It felt absurd, like they were grasping at straws, trying to pin the blame on us for something that wasn't even our fault. The management was adamant that we had violated this unusual lease provision and insisted that we were responsible for the damage, threatening to fine us. It was especially frustrating for me because I was in law school at the time, and I couldn't believe I was dealing with such a bizarre, overreaching clause in a contract I had signed without thinking it would ever be relevant. Luckily, I was able to push back and argue our way out of it. I knew there was no way they could reasonably prove we were the ones responsible, especially since we hadn't even been putting anything strange down the drains, let alone pasta. After some back and forth with the property manager and presenting our side clearly, they eventually dropped the matter. Still, the whole situation was a lesson in how even the most seemingly innocuous clauses in a contract can come back to bite you, and you never know when you'll need to be prepared to defend yourself against something completely ridiculous. It was a good exercise in reading the fine print, but it was also a reminder that some rules and leases can be just plain absurd. Story 16. Though I'm not a lawyer, one of the strangest contract stories I've heard came from my own family. When my parents were in the process of buying a house, they did the responsible thing and carefully reviewed the contract before finalizing the purchase. In the middle of all the usual clauses about property and conditions, they stumbled upon something completely unexpected, a clause that required them to keep all the cats that currently lived in the house. Not one, not two, but 3 long-haired cats. The issue? My mom is allergic to cats, so keeping them wasn't an option. Naturally, they had the clause removed from the contract before moving forward with the sale. But even after removing the legal obligation, when they finally moved into the house, the previous owners left the cats behind anyway. It seemed like the former homeowners were trying to pass off the responsibility for their pets in a pretty sneaky way. Fast forward 8 months, and despite their best efforts, my parents still have the cats. They didn't want to just abandon them, so they've been feeding them and keeping them as outdoor cats, doing what they can to care for them while they search for new homes. Finding new families for the cats in central Pennsylvania hasn't been easy, but my parents are hopeful they'll find the right homes for them soon. It was definitely one of the more bizarre experiences they've had with a home purchase. Who would have thought reviewing a real estate contract would lead to unexpected pet ownership? It just goes to show, you never know what you'll find buried in the fine print. Story 17. I'm a law student, not yet a lawyer, but in one of my contract law classes, my professor shared some fascinating cases that really emphasized the importance of carefully reviewing contracts. One case in particular stood out, where a company attempted to insert a clause into a contract in such pale gray font that it was nearly invisible, clearly hoping that the other party wouldn't notice or might assume it was either a break in the text or an invalidated clause. Sneaky tactics like that show how far some parties are willing to go to get the upper hand, banking on the idea that the fine print might slip by unnoticed. Another case that stood out was one involving a placement agency that inserted a rather harsh clause into its contracts. This clause stated that if any of the employees they placed were to take another job outside the agency, they would be forced to pay a hefty $1,200 fee. The problem arose because the agency wasn't fulfilling its promise to provide employees with enough hours to make a decent living. With such limited hours and insufficient pay, many of the employees were forced to find second jobs to make ends meet. When the agency found out, they began suing the employees, invoking the penalty clause. Thankfully, the court sided with the employees in this case. The judge ruled that the exclusivity clause was abusive and invalid, citing that such clauses could not stand under the Civil Code of Quebec, 1437 CCQ. Because the primary clause fell, so did the penalty clause, which was considered excessive and unfair under civil law. In civil law, liquidated damages, also known as penal clauses, are permissible but must be proven to reflect real prejudice, not simply designed to punish or exploit the weaker party. This ruling was a huge win for the employees, ensuring that they weren't financially crippled by an unjust contract. I thought this case was a great example of how protective the law can be for smaller parties in contractual disputes, especially when clauses are designed to exploit or harm. It's a reminder to always be wary of clauses that seem overly harsh or unreasonable. The law isn't always on the side of those with the most power, and sometimes justice prevails in unexpected ways. Side note, My professor used Agence de Placement Hélène Roy LTC. Ryu, 1997, RL, 297, CQ, to illustrate this concept, which I found incredibly insightful. Also, English isn't my first language, so I hope this explanation made sense. It was my fear of using the wrong legal terms that made me feel cautious, but I think I'm getting the hang of it now. Story 18. I am an attorney working for a large university, and a few years ago I was involved in a situation that became quite a legal tangle. The university had issued a competitive bid for a near-exclusive dining services contract, one that applied to every part of campus except the libraries. After a thorough bidding process, Company A emerged as the winner, securing the campus-wide contract to provide dining services everywhere on campus, except, of course, in the libraries, where another bid would be held separately. Not long after Company A had secured their contract, the libraries put out their own request for proposals for dining services. This time, Company B, which happened to be Company A's largest competitor, won the bid to operate in the library spaces. Everything seemed fairly routine at first, just another day at work dealing with contracts, until we began reviewing Company B's contract in detail. As part of their contract, Company B had provided several exhibits, including a technical exhibit that outlined things like the number of employees they would hire, the equipment they would bring in, and other operational detail. It was the usual stuff. However, as I was going through the final pages of the exhibit, I noticed something odd. There, tucked away in the middle of the last page, in extremely small, almost unreadable font, about 6-point font size, was a clause that took me by surprise. The hidden clause stated, "The university hereby terminates its contract with Company A and hereby appoints Company B as the exclusive provider for all dining services on campus." It was a blatant attempt to sneak in language that would have voided Company A's campus-wide contract and handed the entire university's dining services operation over to Company B without the proper process. It was a direct, underhanded attack on Company A's position, concealed in a part of the document where no one would expect to find such a significant statement. Luckily, we caught it in time. I immediately flagged the clause, and after a careful review, we deleted it from the document. Had it gone unnoticed, the university could have been embroiled in a massive legal battle between the two companies, and it would have been an administrative nightmare to untangle the conflicting contracts. We were able to proceed with the contract as originally intended, with Company B confined to operating only in the libraries and Company A maintaining its contract for the rest of campus. It was a close call, and a reminder of how important it is to always read the fine print, even the tiniest, most inconspicuous parts of it. Story 19. I once had the task of reviewing a business sale contract for a client who was in the process of purchasing a convenience store. The deal seemed fairly straightforward at first glance, but as with any legal document, it's important to comb through every clause carefully. As I delved deeper into the contract, I noticed something that immediately caught my attention, something that, to be honest, left me both amused and a little shocked. Buried in the midst of the usual legal jargon, there was a rather strange provision. The attorney who had drafted the contract, representing the seller, had slipped in a peculiar clause. It stated that the attorney would be entitled to a 6-pack of beer of his choosing for free every time he visited the store. Not just once, mind you. Every single time he came by, he would be allowed to help himself to a 6-pack without charge. It was an unusual, almost cheeky addition to an otherwise standard contract. I couldn't let something like that slide without bringing it to my client's attention. When I pointed it out, my client was understandably surprised, and we both had a good laugh at the absurdity of the situation. But of course, this wasn't just a quirky footnote to overlook. It was unprofessional. I couldn't imagine why a lawyer would add such a clause unless he thought no one would ever notice it. When I confronted the other side about it, I expected some kind of explanation. What we received was both amusing and a little troubling. The seller's attorney claimed that he had included the beer clause to see if anyone was actually reading the contract. Apparently, he had thrown it in there as a sort of test, assuming that if no one caught it, he might just walk away with free beer for life. While the client and I found it amusing, it also struck me as exceedingly unprofessional. Contracts are serious legal documents, and to treat them as a playground for hidden jokes or personal perks erodes the trust and responsibility that come with practicing law. It was an important reminder that lawyers need to act with integrity, especially when their clients' interests are at stake. Needless to say, we had the clause removed immediately, and the sale proceeded without further incident. But I always think back to that contract whenever someone mentions reading the fine print. Story 20. Years ago, I found myself in a rather interesting situation when I was tasked with drafting an operating and maintenance contract for a small business I was part of. It was just the two of us, and we had been approached by a much larger company that wanted to hire us for some technical work. The problem was, I had absolutely no legal background or formal qualifications in contract drafting. But we couldn't afford a solicitor, so the responsibility landed on me, and I had to make the best of it. I figured the key was to keep things as straightforward as possible. I focused on the basics: what services we were offering, how much they had to pay us, and the terms under which we would work. It was an important contract for us, and I put a lot of effort into making sure everything was clear and easy to follow. However, as I worked on the document, I also threw in a little joke to lighten the mood. I added a clause that read, "Party agrees to supply tea and biscuits to company personnel making site visits for the purpose of carrying out the provisions above." It was just meant to be a placeholder while I worked on the more serious sections of the contract, something that made me laugh during the tedious process. I fully intended to remove it before sending the final version over. But as these things sometimes go, in the rush to get the contract finalized and sent out, I completely forgot to take that little joke out. I didn't even realize my mistake until much later. Fast forward to our first site visit. My colleague and I showed up, ready to get to work, and to our surprise, the company had prepared a spread of tea and biscuits for us, just as the contract had stated. They greeted us warmly and said something along the lines of, "As per the agreement, here are your tea and biscuits." I was momentarily taken aback, and then I remembered the joke clause I had left in the contract. I couldn't believe they had actually taken it seriously. We all had a good laugh about it, but the best part was how kindly the larger company handled it. Despite my oversight, they treated the whole situation with humor and hospitality, and we got the job done without any issues. From that day forward, every site visit started with tea and biscuits, a tradition that, though unintentional, became a hallmark of our working relationship. It was a great reminder that sometimes even mistakes can lead to something unexpectedly pleasant. Story 21. Throughout my career, I've reviewed countless settlements and contracts, but fortunately, I've never come across anything too sneaky. Most of what I've dealt with involved minor adjustments of dates for compliance with terms, nothing particularly underhanded. However, during law school, I learned about some truly bizarre legal tricks, especially when we covered click-wrap agreements, the online terms and conditions that most people barely glance at before clicking accept. One story that sticks with me to this day is a particularly amusing and slightly unsettling April Fool's Day prank by a British company. The story goes like this. GameStation, an online retailer, decided to have a bit of fun with their customers by slipping an outrageous clause into their terms and conditions. The clause stated that by making a purchase, the buyer was essentially surrendering their immortal soul to the company. Yes, you read that right. They were claiming ownership over their customers' souls. Of course, this was meant as a joke, but there was an opt-out option. However, very few people actually opted out. Why? Because as we all know, hardly anyone reads the fine print of those lengthy terms and conditions before clicking I agree. The clause was harmless in this case, but it highlighted a larger issue. Most people don't take the time to fully understand what they're agreeing to when making an online purchase. The company even admitted that thousands of people had unknowingly given up their souls before the prank was revealed. For their efforts, GameStation later sent emails to those customers, notifying them of the joke and returning their souls in good humor. While this particular story was a lighthearted prank, it serves as a reminder of how easily important details can be missed when it comes to legal agreements, especially online. The humorous story often comes to mind when I work on contracts or settlements today. It reminds me to always stay vigilant and pay attention to the fine print, even when the terms seem routine. You never know what might be hiding in the text.